Can we proceed now? I take it that everybody that should be here is here. This is the judgment in this application in which the applicants seeks an order that recording devices installed in a vehicle owned by her husband and used by her constitute unlawful invasion of her privacy, and that they should be removed. The facts of the case are as follows. The parties are married to each other out of community of property and have been so married since 2011. They have 2 minor children. The applicant, being the mother, has instituted divorce proceedings against her husband, the respondent. And in her particulars of claim, she contends that the reason for the irretrievable breakdown of the relationship, amongst other things, is that the respondent is prone to fits of rage and violence, that she drinks excessively, and that he is physically abusive, to the extent that on an occasion he made a threat to her life. The defendant denies these allegations. He pleads that even though he has lost temper at times and has shouted, he would not become physically aggressive against either the applicant or the children. He concedes that he has on an occasion threatened the applicant whilst upset, but he pleads that this should not be construed as a threat on her life. The respondent also lodged a counterclaim in which he admits that the relationship between him and the applicant has irretrievably broken down, however, not on the grounds advanced by the applicant. On his version, it is rather the applicant who is emotionally and verbally abusive and would scream at him and the children, and drinks excessively, and also neglects the children. Shortly after serving the summons on the respondent, the applicant left the common home with a vehicle owned by the respondent. She then sent a text to the respondent telling him that she had left with the children and indicating to him that she would not be disclosing her whereabouts. She also warned the respondent not to try and find her. The respondent thereafter brought urgent proceedings in the Children's Court to ensure or to try and secure the return of the children. She accused the applicant of kidnapping them. However, he subsequently withdrew the urgent application. In the evidence that forms part of the record before this court, it appears that the vehicle is fitted with a GPS tracking device, as well as a dash cam, which were installed by the manufacturer, according to the respondent. These devices are then connected to an application app that is connected to the respondent's phone and transmits data to his cell phone. For some reason, the respondent withdrew his urgent application in the Children's Court, because he says he was able to discern using the GPS tracking device that the applicant was staying with her mother, and therefore the urgent application had become unnecessary. The dash cam installed in the vehicle has a built-in microphone, and some of the conversation in the vehicle have been recorded. The respondent contends that the evidence from the recorders supports his case, particularly that the applicant verbally abuses the children. Transcripts of the recordings, he says, will be used as evidence in the divorce proceedings. The respondent then emphasizes that the GPS tracker were features that were installed by the manufacturer and that they should be removed as they serve as safety devices for the benefit of both the applicant, but more importantly, for the children. He argues that in the event of an accident or hijacking, it would then be easy to determine the location of the vehicle and its occupants through the devices. He contends that the importance of these devices for purposes of safety and security of the children should not be underestimated. In argument before us, both by counsel who appeared on behalf of the respondent and by the amicus who assisted the court, the right of the respondent as the father of the children to conduct himself in this fashion as an interested party and for the benefit of the children was highlighted. Further, it was denied that the installation of the devices constitute an infringement on the privacy of the applicant. The primary intention or benefit initially, according to the respondent, were the low premiums offered by insurance companies as a result of the tracking devices. There seems to be no dispute between the parties about the applicant's right to privacy, particularly that she enjoys privacy under the Constitution. In this respect, Section 14 of the Constitution reads as follows: that everyone has the right to privacy, and that this, which includes the right not to have their person or homes searched, their property searched, their possessions seized, or the privacy of their communication infringed. Our courts have, in numerous instances, pronounced on the importance of this right. The respondent contends, however, that the invasion or the infringement or his perceived infringement of this right is justified on the basis already stated that the applicant has been caught in the recording devices conducting herself in an abusive fashion with regard to the children. The details of the abuse are, however, not very clear. The respondent, therefore, submits that it was submitted on his behalf that a case has been made for limitation of the right to privacy enjoyed by the applicant under Section 36 of the Constitution. Indeed, Section 36 of the Constitution provides for limitation of rights that are protected under the Bill of Rights. It reads as follows: the rights in the Bill of Rights may be limited only in terms of law of general application to the extent that the limitation is responsible and justifiable in an open and democratic society based on human dignity, equality, and freedom. The requirements for limitation of a right protected under the Bill of Rights are the following. It is the nature of the right. It is the importance and purpose of the limitation. It is the nature and the extent of the limitation. It is the relationship between the limitation and its purpose. Lastly, it is whether there are any less restrictive means to achieve the purpose. In this instance, as I have set out, the nature and extent of the limitation being the constant continued surveillance of the applicant is quite egregious. Essentially, it means that at all times that the applicant is in the vehicle together with the children or with anyone else, there is no privacy. Firstly, it will encroach on the rights of the applicant herself and the children. Not only that, anyone who would be in the vehicle with the applicant or the children would have their rights infringed with not so much as a warning. Such egregious invasion should only be permitted in the most justifiable of circumstances. No such case has been made in this instance. The purpose of the relief sought in the counter application, that is that the surveillance, the devices be left in the vehicle, has been described as the protection of the children. The respondent seeks continued surveillance because he is the father of the children. The Children's Act sets out the rights of the parents in relation to their children. The respondent, as already set out, first approached the court, Children's Court, seeking an order for the return of the children. That, in my view, was the correct procedure. Or a similar application could have been instituted in this court. The applicant has all the evidence that he needs for the purpose that he says he wants to use it for. That is the protection of the children against the applicant. Had the application initially issued or an interdictory application been sought by the respondent in this case, proper evidence for determination of custody rights of the children under the Children's Act, even if on a temporary basis pending the divorce proceedings would have been procured. That is a less restrictive procedure of protecting the rights of the children. That not having been done, no case was made for opting for the most invasive of procedures, even if it was for protection of the children. In any event, the relief sought in the counter application would not protect necessarily the children. Instead, it would, if the allegations by the respondents are true, even expose them to further harm if it were to be believed that the applicant is abusive towards them. That being the case, no proper case was made for the continued surveillance of the applicant. In the counter application, the respondent sought that the evidence that he would obtain from further surveillance of the vehicle be admitted in the divorce proceedings. This court would not in any event have been the proper forum for such an application, because a relief to that effect would properly be determined by the trial court. However, because of the conclusion we reach on the issue of whether the infringement of the applicants and even the children's right to privacy was justifiable, it is not strictly necessary to deal with the issue of admissibility. Having considered all these factors, the relief we grant is the following order. 1, the respondent is ordered to facilitate within 7 days of this order and pay for any costs related to removal of the devices installed in the vehicle. 2, the respondent is ordered to pay the legal costs occasioned by the applicant in this application, such costs to include those of the employment of 2 counsel. That is the order. Take it that my colleagues agree.
We agree.
Thank you.
Justice.
We have reached the end of these proceedings, and I do want to extend a word of gratitude to all the counsel concerned for their submissions. The case was not an easy one to argue, particularly I think the respondent had a difficult case to answer, and counsel are commended for the brave manner in which they ensured that the rights of all the litigants involved and the children are protected. And a special word of gratitude to the amicus for coming forward to assist the court in such a difficult case. Thank you to all. The court now adjourns. Aisha, I'm not sure whether the rest of the ceremony will come onto this link or we should just leave it.
Hi, Justice. Thank you very much. No, the rest of it will continue on this link. Thank you very much to our justices, and thank you to counsel and everyone else for attending. So the court proceedings have been concluded. The rest of the program right now, I would like to please call on Luminary Advocate Tiny Seboko to say a few words and to present the beneficiary of the scholarship award, which is sponsored by ZTA Attorneys and Conveyancers.
Thank you very much, Promise. Good afternoon, everybody. It is 2:10 and I intend not keeping everybody very long. Aisha, am I audible?
We can hear you.
Thank you. Shall I proceed?
Please do.
Thank you. Ladies and gentlemen, Justice Dambuza and your brother and sister, our bench for today. To us as SABWiL, this indeed is a huge, momentous day. We recognize Judge Dambuza, our current sitting judge of the Supreme Court of Appeal, for gracing us with your presence, your wise wisdom, and for sacrificing your precious time to us. We congratulate our participants, and to all of you, we say we are proud of you. And I also want to add that all of you looked very good today and well done. We applaud your bravery for participating. We applaud your bravery for joining the fraternity. We thank you and we commend you for following the footsteps of our heroes and sheroes in the profession. For today's purposes particularly, as we have seen from the short profile we received of Judge Dambuza, a judge who has roots in the villages of the Eastern Cape. We thank you and encouraging you for commencing that journey. To all our members in SABWiL, I would like to start today by again going back to reflect on Judge Dambuza. I'm sure as a young girl from the Eastern Cape, the judge had no idea that one day she will soar to the heights of where she is today. The judge has acted as judge of the Constitutional Court. She's a chair of the Rules Board. She also chairs the Judges African Education Network on Environmental Law. Why am I spending so much time on speaking about Judge Dambuza? It is because she represents exactly what we stand for. What we stand for, firstly, is to recognize and appreciate women who we refer to as imbokodo. And we always say in our mission statement, Wathint'abafazi, wathint'imbokodo. To us as the directors and the alumni of SABWiL, we are happy today that indeed our choice was not wrong. A choice of a woman who carries, epitomizes, and lives our dreams as young girls and boys who aspire to be great lawyers, who aspire to be contributors of substance to this profession. We do not, however, even as we encourage you today, all of you, participants and observers, we do not for a moment think that there will be nothing in your lives, in your ways, which try to clip your wings. To clip your wings as you try to soar. To clip your wings as you try against all odds. Because for most of us, in fact, a large majority of us, the fact of passing through and progressing through the first year is to us what looked and seemed like an impossible dream, not only for us, but for our families too. And even as we attempt to obtain these qualifications, sometimes we are hurt by the words people say to us, by the words people say even to our mothers and siblings. When in our communities, your mother and your sibling will be told, even you will be told sometimes that you think you will be a lawyer, you will not finish that degree. You're a woman, you cannot finish that degree. We are saying to you, do not be defined by the words of those who don't know you, but try to define yourself for yourself. We are saying to you, you have a double duty, a duty to self, a duty to your family and community. Because as young black girls and boys, we know that we are reaching this far for our families too, our families' names, our families' pride. We do this studying and achieving, not for ourselves as individuals, but even for that uncle who is known to be the most drunkard in the community, that uncle that will call you from the tavern and speak to you just because he's a lawyer and he's proud of you. He wants his drinking mates to know that he's got a nephew and a niece who are lawyers. We are excited today to congratulate you, to say, shine on, rise on. Don't allow that star to fade. May it rise, rise, and rise again. Yes, there may be pressure to meet the expectation of others. Do not allow it. May your conversations be known to yourself alone. May those conversations be rooted in the expectations not of others, but for you and those who look up to you. For you and that mother who is a street hawker selling apples and bananas by the side of the road in that village, who knows that as she braves the elements, as she braves that weather each morning, is so that you can have that textbook, is so that you can have that data and that Wi-Fi. Have faith in God's plans for you. And remember always that what stands between you and achieving your dreams is the effort which you are willing to put to attain those dreams. Stay true to yourself. Stay true to your most authentic self and trust that you will do well. You've taken the first step. You know how to pass examinations. You've passed matric. You've passed your first and your second. Maybe even you are in your final year today. So passing an examination is no hindrance for you to attain those goals. Pull yourself out of those emotional debts. And I know there are plenty of them. And I'm sure even Judge Dambuza, who hails from the villages of the Eastern Cape, would agree that those emotional debts may be self-doubt for some of us, maybe families' poor circumstances, maybe an unstable family, maybe and the impact of COVID on our families. We say rise above them because we have seen that you are able to. We have seen that you are a brave boy and girl. You put yourself forward in front of all of us, in front of Judge Dambuza and her two colleagues, and you try, and they engage you and you try. What a brilliant opportunity. This is exactly what happens in a real court life. The judges engage you. You prepare your case and you think you're done and you think your submissions are brilliant and you will walk away with that order. And the judge comes from an angle you didn't anticipate. That should not dampen you. See how your own Judge Dambuza has soared. That is the spirit. That is the spirit we want all of you, including us, to emulate. See that she still contributes. She still sets time aside to lift us up. She still fulfills what I've referred earlier as a double duty. Today, all of us must connect to that magic. We must connect to that magic of selflessness. You never say to yourself, I'm a judge of the SCA, I am done. No, the responsibility continues. May that magic continue to shine. We know you've got it in you. You've got it in you to contribute to your family, to your friends, to your community. Rise above the noise that we know is there around you. Rise above that noise that threatens your dreams. Today, we are saying, use your missteps and errors for motivation. You might have failed a few courses. You might have performed below your expectations in some of them. Those are the missteps and errors I'm talking about. Those are the missteps and errors that must motivate you today to be our next Judge Dambuza, to be our next Justice Khampepe, to be our next Chief Justice. Why not? The sky is the limit. They did it too. You can do it. You've got it in you. You have heard the magic. You have seen the spirit of Judge Dambuza. Impart it. Let's adopt it. Let's make it possible. Never bother yourself about what really other people say or do, because what really matters is that dream that you are busy pursuing. Actually, as I speak to you like this, I remember the words of the song by Luther Vandross, The Impossible Dream. Pursue that dream. When I speak around the country to grade 7 and 6 pupils, I remember Twinkle, Twinkle, Little Star. When I was in school myself, I don't think I knew the words or knew what they meant or their significance. Twinkle, twinkle, little star, how I wonder what you are. Keep wondering, keep searching, keep inquiring. Never waste your time sleeping. You'll sleep enough when you are dead, because you cannot be better than your opponent if you want to sleep more than they do. You've seen what happens in real life courts. The judge is going to ask you, but is there no alternative remedy? Is there no harsher remedy? Because if you don't read those cases, you will not realize that don't always go for the jugular. There are other means of obtaining your order using less harsher ways. We thank you today. We thank you today and we say, well done. Well done and continue. Aisha, I know you always don't want to be mentioned, but I'm sure I speak up on behalf of myself and the board when I say, we are happy you made us a part of your dream. We are happy you carried us through to see this thing being realized. We share in your passion. We love you and we encourage you, and we shall try. Yes, we do. I do fail you most of the time, but your passion is real. Your passion is needed. Your passion is important as it encourages. Thank you for roping us all in. May we also with you try in whatever little way that we can. In whatever little way that we can today, as we join forces, and thank ZTA attorneys for sponsoring our prize today for our beneficiary. At this time of my speech, which yes is long, but I was hoping it would be short, it gives me great pleasure to introduce the recipient of this year's inaugural scholarship. What a beautiful day it is for all of us today. What a momentous achievement. From back in the day when Aisha was conceptualizing this entity and she was putting together a board, together with the chairman, our esteemed senior counsel, Ngosi Thomas, we are indeed proud to introduce a beautiful girl from KZN, our member who joined us just before COVID, our member who held on to the hem of one of our members in KZN Advocate Ready. Shadowing is such a brilliant opportunity, Aisha. It's an opportunity for that girl that shadows or that boy and the one that is the mentor or the principal to share themselves, their space, their time, and their little knowledge. To learn, because the reality of the matter, Judge Dambuza, is that these beautiful boys and girls had their high school and universities at different times. They are exposed to much more than we were. They have access to internet when we didn't. Everything they need is on their phones, while you and I had to walk to that public library or had to walk that long distance to find a quiet place to study. Ladies and gentlemen, I want you to know today that as you think that you're learning from us, those that you shadow, we learn much more from you, because your inquisitive brains and your hard-working spirit is an eye-opener to all of us. We thank you very much, and our recipient, who I think is very well deserving, Miss Promise Songwa. If you may show your face, please, to all of us, as we applaud you, as we congratulate you on a well job done. We have, yes, you. When you introduced me, sadly, you didn't know that I'm going to be bestowing this prestigious award on you. Very well deserving. No doubt in our hearts and minds that you shall use it well, that you shall use it to improve yourself, to improve your family, to improve your community. Learning doesn't end today. Learning doesn't end today. Even in the courts, you will continue to learn. Even in the courts, you will be beaten by a judge who interjects. But after you walk out that court with your tail between your legs and you get home and you reflect, you will in fact realize that it was an opportunity to learn. It was an opportunity for you to see that which you have missed. This is indeed a noble profession. I know that you are very much more younger than what I am, and you are exposed to much more in the internet. But this remains a noble profession. Despite the bashing and the criticism of our judges, South Africa is one of the best judiciaries in the continent, if not the world. Remember, even the developed world still looked up to our constitution. And seeing Aisha, I'm sure that's a cue for me to say that is all. Thank you. Well done, Promise. You deserve it, and I know you shall use it well. Thank you, ladies and gentlemen. Thank you, Justice Dambuza and your colleagues. We really appreciate your contribution and participation. And I'm sure that this is not the last time that we see you today. Ms. Bowen and Mr. Nyangiwe, a special thank you to both of you. Good afternoon.
If I may say something to our council of today, aside from terrorizing them during the hearing, just to add to what you've said, I know that it's late and I'm hungry. I want to go and have lunch. But I just want to add to what has been said and say that what you must remember in practice is that all these disputes are at the heart of all disputes, which we will shroud in complicated sounding legalese, are simple facts of what happened, who started doing what, and then what was the response. So if your approach is simple, I think personally that the best lawyers are the ones who are able to simplify things, to simplify them such that they are understandable to their own clients. And to just keep things simple. Of course, the legal principles that will be applicable may be couched in very cumbersome terms. But if you go back to your facts, to both versions or to all versions that you have, even if it's how many times, to be able to ascertain what is the issue between these people. If you are able to identify your issue, I think that's the most fundamental step that will get you anywhere. And then secondly, is to keep on, whilst you're working, assessing that issue that you want to resolve and the manner in which you want the court to resolve it for you, which is the order that you want. That's the reason I seemed to be harping on the connection between the relief, the case that you make out and the relief. If you've identified the problem between these people properly, you will be able to fashion an order that is appropriate to the problem that they have. I don't want to say much about hard work. I'm sure you hear that all the time, and focus and all those things. But the most important thing that I heard this afternoon is that you remain true to yourself. And lastly, the minute you think that there will come a stage when you are not anxious, when you don't have the butterflies, when you're coming to court, or when you are dealing with a difficult case, or when you're waiting for your judgment, you must know that you're missing something. That anxiety is there for a reason. It keeps you on your toes. I still have my anxieties even today. So it shows, I think, that you care about what you're doing and you're not taking yourself and what you're doing for granted. That is my interpretation of why we're always anxious when we're going into court, why we're anxious when we are waiting for our judgments. You must never take your ability for granted. You must never take the seriousness of your matter for granted. It is always because we have, all of us, we have a very great responsibility of trying to assist people in solving their problems. That's all. And thank you very much. I was very impressed with the bravery that I saw today. I could see you were anxious, but the coming out there, and once you start, I could see that you getting in there, you getting carried away, and you want to make your submissions. That's what happens. The fear that is there, or the anxiety, lasts only for the first 5 minutes, and you're soon lost in your argument, and you actually begin to enjoy yourself. And the exhilaration of it all once you finish. The only bad thing that should make you feel bad, the only thing that should make you feel bad, is to feel at the end of the day that you did not do your best for your client. If you do your best, it does not mean that you're always going to get the orders that you want, but you will be left with a feeling that I did my best for my person, despite whatever happened. That's just life. Thank you very much, Aisha and everybody.
Igama, lamakhosikazi, malibongwe. Thank you so much, Justice. And to the Council, your preparation exemplifies what we are trying to achieve, and I have no words, because you really soared. So very, very well done, because the preparation, without preparation, the execution will fail. So as Justice Dambuza has indicated, if you do your very, very best, then what more can we do? And when I joined the bar, when I started, I was a perfectionist, and I learned very, very quickly that there is no such thing as perfection. And I learned that on my feet, that the way that I as counsel would be able to sleep with a clean conscience and at peace is if I embraced every matter and I did my ultimate best. So that those words, that comes from experience, and that comes from my experience, and that's from the wisdom of our Justice Dambuza through her decades of being in the legal environment. Do your best, and then surrender, then let it go, because it's in the judicial system. So what happens is, if I do my very best with whatever matter, I release it, because I'm not the final, as an advocate, I don't have the final say. My job is to assist the bench, to help the judge come to the right conclusion with ethics, because we have to disclose all the cases, even the cases that are adverse to our client's interest. And we need to grapple. So that is what counsel does. Counsel's primary role is to assist the judge and to advance the best interests of the client. So we have a duty to court, and we have a duty to client. And if we do our very, very best, then I believe we will be close to actualizing what our passage is, to actually honor this role of being a legal practitioner and an officer of the court. So I've now piggybacked on the wisdom of what Justice Dambuza has indicated about doing our very best. And truly, that's how you learn. So after we've embraced the matter, done our very best, and then what we do is, in that context, because you're not on your own, you have an opponent, and you have a bench, and you have a client, and you have an attorney. So you're part of an ecosystem. So there will be feedback. It will come in different forms. It may not be in the form that's a training session. So what happens in litigation? It won't be in a kind form. It may not be in a form that exemplifies Ubuntu. So it may be in a way that develops your reflexes, it develops your skin. So we develop very thick skin. But I think that the way to deal with the feedback that will be quite brutal is just to think about being in a boxing ring. So, you know, when we litigate and we're in a court, everybody is focused on the issue before the court. So it's not really personal. If the justice and the counsel is grappling, I think what happens is those that aren't trained in litigation, they may not understand that dynamic, but there's a mental dynamic because there's minds at play. And we are trained in how to present our dispute to judicial officers in a way that takes away the bias, the complexity of the personal interest. But it is a way that it doesn't come naturally, I must say. So it is part of the training. So most people, what would happen is if you start in the litigation, it may feel quite brutal in the beginning, and you may leave because you think, why should I endure that? Why should I subject myself to that beating in court or that, you know? But I think you need to look past it. It's not personal. So what happens is if you understand that the justices, your opponents, the clients, the clients may have a different interest. Perhaps your opponents have a different interest, but the justices, the judiciary is certainly striving to apply the law and to uphold the integrity of the Constitution, the supremacy of the Constitution, and the rule of law. So if one judge comes and brings in only their personal dimension, we corrode the rule of law, because that's why we have cases. That's why we have precedent. We have decades of case law where judges grapple together. We have the Constitutional Court cases. We have the Supreme Court of Appeal cases. We have the Gauteng Division cases. We have the Western. We have a body of law. Now, why is this so vital? It's vital because it takes away the fact that, oh, today I'm in a bad mood. I want to do this with person X. So it takes away a rule of man. It takes away a rule of the king. It makes it the rule of the law. So as a judicial officer, and as a legal practitioner, I am accountable to the judiciary, and the judiciary is accountable to the Constitution. So there's something bigger than us as individuals. And I think if you're long in this profession, we all develop that sense that it is bigger than us. It is about the rule of law, and we truly grapple intellectually. And it is such I think it is such a divine pleasure, that challenge that we have with the bench, that challenge that our opponents bring. Because what you have is you have heads of argument. You have an issue. The clients have this issue. So we take that issue and we contextualize it into the rule of law body. What does the rule of law, what does the case law say? And when we see what the history, the thinking, the intellectual, the richness of how the law has developed, what has the last judges said on this matter? And if we can't find the current judgment, we go back to as far as we can find it. But that is all very vital, because otherwise we have the rule of the king, or we have the rule of the president, or we have the rule of man, we have the rule of the judge of the day. That is not what we are about. We are about the rule of law, and a founding value in the Constitution is the rule of law. A founding value is the supremacy of the Constitution. So SABWiL, South African Black Women in Law, we founded on dignity, equality and freedoms, and we infuse that in Ubuntu and Zenzele. So today, I would truly submit that today we have actualized Ubuntu and Zenzele. We are doing it for ourselves. We are in a training environment. And I think to just add the value of the training environment linked to what I said earlier about litigation and how rough it can be, and how I piggybacked on what Justice Dambuza has said about doing our best. Now, if we link that, the difference between today and litigation, the marvel and the diamond of today is the feedback. So you are in a kind environment. You are in an Ubuntu and Zenzele environment where we can take the time and understand that you are aspirant lawyers. So it's really not the issue. The issue here is linked to you. So part of this court is the best interests of the learner and the supremacy of the Constitution. So the SABWiL Human Rights Court looks at your best interests, whereas in a court of law, it is the rule of law, it is the constitutional values, it is the law, it is the client, what the issue is that the client brings, and what does the law say. And there is a process, because this is a section 34 of the Constitution, access to the court. Matters must be in a public forum, and we have that access, but access means that the rule of law will be applied in a public hearing that is fair. So judges protect that. And we as counsel, as you are training, we are there to serve and help the rule of law and the Constitution. So I think if you have Ubuntu in your heart and you have service in your heart, then this profession would very much attract you. I will share with you. So the feedback session is what is really the nugget, because you won't really get that in litigation. You will have to engage with your colleagues. That's why your relationship that you develop with your seniors are important, because we share intellectual capital. We help each other. I will walk away and then I will engage with another colleague. This is what happened. This is what happened. But judges don't tell us that a judge is not there to give you advice. A judge gives a judgment. So there's no feedback session from the judge. The judge speaks to us through a judgment. And that's why the judgment for a judge, a judicial officer, is a very sacred. It's truly, I think I only realized the value of a judgment because I was a judge's clerk. And my judge, said to me, do the judgment. And after I attempted that judgment, I had a profound respect for a written and extempore and the thinking that goes into a judgment, because it is, if you understand what goes into a judgment, you won't simply throw that document. It is a document that is so, it has so much richness. We may not like the outcome, but it must be reasoned. So the judge speaks to us, and whether we agree or we disagree, their only way to speak about the case finally is in the judgment. Then they have to be muted, and the higher courts can speak. This, if it's a local judgment, then the Supreme Court of Appeal speaks. And then if it's a constitutional issue, then the Constitutional Court has the final say. But the judgment is truly, I think, the greatest gift. I would probably encourage you to search for is to be a judge's clerk, because to sit in those deliberations with my justice, to sit on the bench just one step below my judge was such an honor. And one matter we had, it was a murder case, and I still at that time said, oh, I feel so sorry for the accused to the judge, and because the psychiatrist was giving the evidence, and we heard about, it was a Satanistic murder, and we heard about the upside down cross, but we heard about the psychiatric history. So my judge, just shifted my mind in one question, and I mean that was in 1999 when I was a judge's clerk, and that shaped me. And he just said to me, if you're feeling sorry for the accused, how sorry do you feel for the victim? And that just opened a different world. So what I would share with you is that today we have been graced by a Supreme Court of Appeal justice that has a wealth of knowledge, that has looked at judgment after judgment and has identified and can speak on those lower court judgments and can overturn it or agree with it, but looks at it from a different level that our judicial system with precedent has created. What is very interesting is that you know it's good to think about and just know it exists. There are different systems, a common law system, a civil system. So we are very much on the precedent, and that's how we are trained. So it is the stare decisis. And we have truly been honored because the justices that I clerked for were at the Gauteng division, and that knowledge, that experience is invaluable. So today you have you have so much by having engaged with that kind of mind, because your engagement as counsel, you did the work, you did the heads of argument, you studied the issue of the case. You then presented oral argument. But what has happened is it will change. You have changed the shape of your mind, because you have had deliberations with a judicial officer that is seasoned, that is beyond my experience, that is beyond my peers' experience, that is in the highest echelons of the judiciary. So you need to now take today, you need to sleep on it, you need to rest. When this video comes out, you need to watch it all over and you need to look for the feedback. You have guides, you have alumni guides that help you, and I'm very grateful for that. And you have luminary guides that have assisted you. So you can deliberate with them, but take the nuggets. So I would like to truly thank everybody, the council, the justices, for ensuring that we have had such a wonderful time, and I think this is a wonderful opportunity to open it up to any comments. If anybody wants to take the floor and say any last words, because I would like to simply say thank you. Very well done, council. I look forward to welcoming the council as our alumni and continuing our learning relationship.
A very joyous afternoon to our honorable justices, to our honorable founder and CEO, to our NPC board members, to our National Executive Committee, to our luminaries, to our alumni, to our SHRC Council today, and to all protocol observed. My name is Nolwandle Mlalazi, and I am the Deputy President of South African Black Women in Law. And to be quite honest, I really don't know where to start because of the amount of joy and gratitude that I'm feeling in my heart right now. And more especially that Advocate Tiny has said a lot that I would have loved to say. So I really feel like I have no starting point. But for the sake of time as well, I'll just keep my vote of thanks very short and straight to the point. First of all, I would like to extend a very hearty vote of thanks to all our justices for gracing us with your presence today and for sharing with us your valuable knowledge and findings. We know you are very busy. There's a lot that you are doing in your line of work. You also have family. You also have all these things that you could be doing, but you decided to make time and be with us today. And honestly, there's no amount of words that can express the amount of gratitude that we feel about that. And thank you so much for all the knowledge that you shared with our learners. We know for sure that they took a lot, and this will help them as they navigate their spaces in their legal careers. We know they took a lot from you, and for that, honestly, I don't even know how to say it, but we are really grateful. So to all our justices, thank you so much. Thank you so much. Secondly, I would also like to take this opportunity to place our hearty thanks to our founder and CEO, Advocate Tyree, for the support, the guidance, and every little thing that she has been doing throughout the years in order to empower the youth, in order to give us opportunities, in order. Sometimes I really feel like Advocate Tyree doesn't get the recognition that she deserves because she's really doing so much. Speaking for myself, I know that I am where I am today, partly because of the wow. I'm where I am today, partly because of the teachings that I got from Advocate Tyree. I remember when I met Advocate Tyree, and then she was emphasizing so much about the spirit of Ubuntu and Zenzele. And I knew from that moment that I really need to stand up for my dreams. I really need to go for things that I believe in. I really need to chase my dreams. I remember this one time when we were at Constitution Hill, and she was saying to us, people who love you can only do so much for you. They can only go to a certain extent in order for them to help you get to where you want to be, but it has to come from you. It depends on how much you want it. It depends on your own drive. So ever since that time, I think I was 22 at the time, I really grabbed that, and I made sure that when I want something, I really go after something. I don't wait for people to help me out. Of course, I do need the help, but at the end of the day, it all has to come from me. I have to put in the work. I have to put in the energy. So, Advocate Tyree, thank you so much for everything that you do and that you have done to empower the youth, to uplift the youth, for the opportunities that you give us, for the amount of work and effort that you put in order for all these events to be a success. We are truly honored, and we are really grateful for everything that you have done for us, and we hope that you are blessed beyond measure, because we don't even know how to thank you back, but you have done a lot, and for that we are eternally grateful. I will also like to send my heartfelt congratulations to our participants today, our SHRC Council. I remember I was talking to all of you this morning, and all of you were telling me, oh, I'm so nervous, oh, I don't know what to do, oh, but you guys did exceedingly well, and we are very proud of you. Like I have been saying from the beginning, from the time I started talking to you guys, the greatest step that you took was applying for these opportunities. And because that's what SABWiL is infused in. We so much believe in the spirit of Zenzele. If you don't apply, no one else is going to apply for you. If you don't take it up upon yourself to do what you need to do to get to where you need to be, no one is going to do it for you. So we are really proud of you for having come this far. We know it wasn't easy. We know the amount of work that you put in, the effort that you put in. It wasn't easy, but look at you. You did it. Well done. We are very proud of you. Talk about the grilling at court. You guys are really brave and courageous, because I was just sitting there when the justices were grilling you. I was just sitting there wondering, like, what would I be saying if it was me? How would I be responding to this? But you guys really did well. I'm very proud of you. SABWiL is very proud of you. And we hope that the lessons that you got today are going to help you in the long run. We hope that you are going to use the lessons to navigate your own way in your own legal careers. And yeah, we are really proud of you, and we know that you will manage. Last but not least, I would also like to send my heartfelt congratulations to our alumni events coordinator, Promise Longwa, for winning the SABWiL Scholarship Award. We are very proud of you, girl, Vuk'uzenzele, and you are so deserving. I've told you this so many times. You really work so hard. So congratulations, Promise. We are very proud of you, and many thanks again to our sponsors, ZTA attorneys and conveyancers. Words fail me when it comes to you, because we know the amount of work that you put in towards the betterment of our youth, and SABWiL is eternally grateful for your never-ending support. Thank you very much, everyone. I will leave you all with the words of Kailash Satyari, which say, "The power of the youth is the common wealth for the entire world. The faces of our young people are the faces of our past, our present, and our future. No such man in the society can match with the power, idealism, enthusiasm, and the courage of the young people." So, to South African Black women in law, thank you so much for empowering our youth. Thank you for uplifting our youth. Thank you for all the effort that you put towards the betterment of our youth. Igama lamakhosikazi, malibongwe. Thank you so much, SABWiL.
Malibongwe, Igama lamakhosikazi, thank you so much for being here today, and let's continue learning. We're all learning, and we are striving. We're striving to be better tomorrow than we are today, and look forward to our next court. If you have any suggestions of which human right we should grapple with, pop us a note and let's take it forward. Igama lamakhosikazi, malibongwe.